Also, we want to welcome into the conversation. I see criminal defense attorney John Mobley is here too. John, happy New Year to you. Welcome to the conversation. And let me begin with you, John, since Eric and I, we talked about this when we dove into many of the issues, but I want to get your take too. Just looking at the facts as we know them, we've heard both sides speaking up to some degree on this case. We sort of have an idea of where it's going to go. Give us your assessment, if you would, kindly.
Well, I think a couple of different things. I think number one, Julie, I got to call it like I see it. I think the comparisons to this case, to the Kyle Rittenhouse case, are just kind of ludicrous. I mean, there's no comparison. That's like a defendant being charged with murder and then finding DNA evidence and the victim's blood at his home and him saying, well, O.J. Simpson got acquitted, so should I. They're just two different cases. In Rittenhouse, at least one of the people the protesters that were shot had a weapon. In this case, you have the defendant shooting a man that is unarmed, which is, whenever you have using deadly force with an unarmed individual, that's always a problem. Particularly when, in this case, there's some video footage where, prior to the shooting, he got to the altercation with the person that was killed and actually punched him in the face. So I think the unarmed person in this case is definitely a problem in the case. And I think his lawyers, they need to stop playing for the cameras. I mean, there's just this dog and pony show every time you turn around of them making a statement to the press. That doesn't win cases. I mean, what wins cases is what defends your client best is keeping the case in the courtroom. And I think they need to just kind of tone it down and focus on that.